Hello students, welcome to the lecture on agent and agency, and after this lecture we will be able to learn the following objectives. Discuss the meaning of agent and agency, explain agency coupled with interest, discuss classification of agents, describe duties of a principal of agency terminates, describe duration and termination of agency. An agent is a person who acts in the name of and on behalf of another, having been given and assumed some degree of authority to do so. Most organized human activity and virtually all commercial activity is carried on through agency. No corporation would be possible, even in theory, without such a concept. We might say General Motors is building cars in China, for example, but we cannot shake hands with General Motors. The general, as people say, exists and works through agents. Likewise, partnerships and other business organizations rely extensively on agents to conduct their business. The existence of agents does not, however, require a whole new law of torts or contracts. A tort is no less harmful when committed by an agent. A contract is no less binding when negotiated by an agent. Imagine that we represent General Hospital, which independently contracts with various specialists, including a private group of anesthesiologists called private anesthesiologists. Imagine waking up one morning to our morning coffee and paper. Let us now discuss meaning of agent and agency. Agency deals with situations in which one person, the principal, uses another person, the agent, to act on his behalf. Sometimes the acts of the agent are attributed legally to the principal, sometimes not. Delineating the conditions under which each is true are what make up the law of agency. The importance of agency in the common law is shown by its being the subject in 1933 of the second after contracts of the American Law Institute's series of restatements. Clearly, agency is central to business dealings. No owner of a business can do everything himself. He must delegate some things to agents, and this is true not only of large corporations but of sole proprietorships that have employees who work for the owner. In partnerships, the partners act as each other's agents. Agency law has nonetheless been neglected in legal research. The problem is perhaps that it no longer is taught as a separate law school course, but rather is tucked away in odd corners of tort, procedure, contract, and business organization. So, being important to all, it is the focus of none. Since the 1970s, agency has at the center of some of the most exciting research in economics. Economists, including this, have used the idea of principal and agent to explain the intricacies of labor compensation, the organization of hierarchies, the design of securities, and a host of other problems. Different kinds of agencies. There are many types of agencies: express agency, implied agency, agency by estoppels, agency of necessity. Express agency, implied agency. Express agency is created by either an oral or a written agreement between the principal and the agent. It indicates their express intent for this representational status. An agency, in fact, found to be so by the court drawing reasonable deductions from disclosed facts, and it may spring from acts within control of principal and permitted over course of time by acquiescing, although it cannot exist contrary to his express will. Every agent who is authorized to conduct a particular trade or business, or generally to act for his principal in matters of a particular nature, or to do a particular class of acts, has implied authority to do whatever is incidental to the ordinary conduct of such a trade or business, or of matters of that nature, or is within the scope of that class of acts, and whatever is necessary for the proper and effective performance of his duties, but not to do anything that is outside the ordinary scope of his employment and duties. An agency relationship can be either express or implied. Agency is created by implication when, from the nature of the principal's business and the position of the agent within that business, the agent is deemed to have permission from the principal to undertake certain acts. Some act or acquiescence of the principal, express or implied. This authorizes the agent to do all collateral and incidental acts in order to carry out his duties under the agency agreement. Usual authority. This refers to such authority as is normal for the particular type of agents. Customary authority. This is authority which is derived from business usage or the locality, market. Agency by estoppels. The concept of agency by estoppels arises where one person acts in such a way that the other believes that the third person is authorized to act on his behalf and enters into a transaction with the third person. The person whose act induced him to do so is liable for that agreement as if the third person acted on his behalf. Any agent acting outside the scope of his employment will bind the principal by his acts if such acts were perceived as others to be within the apparent authority of the agent in all those cases where the principal has induced the third party to believe that the acts were within the scope of his authority. This doctrine stoops the government from denying the liability of the acts done by its agents. However, there exist many exceptions to the rule of agency by estoppels for government estoppels. Apparent authority and agency by estoppels. Apparent authority, where a person by words or conduct represents or permits it to be represented that another person has authority to act on his behalf, he is bound by the acts of that other person with respect to anyone dealing with him as an agent on the faith of any such representation to the same extent as if such other person had the authority that he was represented to have, even though he had no such actual authority. Apparent authority rests on conduct or words of the principal which lead the third party to believe reasonably that the agent is acting with authority. The American Restatement, second on agency, defines apparent authority as the agent's power to affect the legal relationships of a principal by transactions with third persons, professedly an agent for the other, arising from and in accordance with the other's manifestations to such third persons. If the authority exists, the third party has the same rights and obligations with reference to the principal as he would under actual authority. Apparent authority reflects the concept that a principal is liable for someone's unauthorized acts if the principal is responsible for the third party's belief as to the authority. There is another concept, namely apparent agency, and a distinction needs to be drawn between apparent agency and apparent authority. The key difference between these theories is that a finding of apparent agency will in no way bind the principal. It is only a requisite step to finding authority when actual agency does not exist. A brief history of the doctrine of estoppels. Doctrine of estoppels is the product of several centuries of judicial evolution. 3 species of the estoppels doctrine have evolved so far: estoppels by record, estoppels by deed, and equitable estoppels, also referred to as estoppels in estoppels by conduct. Black's Law Dictionary gives a general definition of estoppels. A party is prevented by his own acts from claiming a right to detriment of other party who was entitled to rely on such conduct and has acted accordingly. Estoppels are based on the ease with which someone could have prevented harm to himself. Having failed to prevent the harm, he is stopped from asserting what would otherwise be a valid claim. Indian Contract Act of 1872 has the principle of agency by estoppels enshrined in its section 237, which says that when an agent has, without authority, done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by such acts or obligations if he has, by his words or conduct, induced such third persons to believe that such acts and obligations were within the scope of the agent's authority. Estoppels are a concept from the common law of tort and evidence, not contract. Estoppels have 2 special features in contrast to other sources of liability. First, the third party's recovery is limited to the losses caused by the principal's failure to prevent the mistake, not expectation damages. Agency of necessity. There is relationship where one of the parties can make essential decisions for another party. This is recognized in the court system and usually will apply when one party is not able to make a critical decision. Agency by ratification. Ratification is a process whereby a principal approves the actions of an agent who has acted to bind that principal without preceding legal authority. The concept applies to a variety of circumstances such as international treaties and constitutional changes, but its most pertinent day-to-day application relates to contract law. In this 2-part article, we will consider the basic principles underlying ratification, the requirements that must be met for it to take place, acts that might fall within its remit, how it is applied in practice, and its effects thereafter. Defining ratification. Ratifying a contract means approving it after it has been entered into by an agent such as an employee who lacked the expressed or implied authority to enter it, and the principal such as an employer has no obligation under that contract or has disclaimed an obligation under it. Conditions for ratification. The three main preconditions are: the agent must purport to act on behalf of the principal. The principal must be in existence at the time of the contract, and the principal must have capacity to enter into the contract. Agency coupled with an interest is when an agent has possession or control of the property of his principal and possesses legal rights against interference by third parties. It is an agency relationship in which the agent is given an estate or interest in the property that is the subject of the agency. It is distinguished from situations in which an agent merely derives proceeds or profits from transactions. An agency coupled with an interest may also be referred to as a power coupled with an interest or a power given as security. In an agency coupled with an interest, the agent has some legal right to an interest in the property that is covered by the agency arrangement, and his position as agent continues until that interest ends.
This is Tom and Susie. They've got a baby on the way and need a bigger home. But what they weren't expecting was just how much work it is to sell their condo. The market is too fast-paced to keep up with, and they have other, more important things to think about. Tom and Susie need professional real estate agents who know how to work in a competitive and saturated market. They need icon agents. With 90% of buyers looking in the internet first, icon agents work as a team to ensure that Tom and Susie's property has the highest internet market visibility possible by plugging into an amazing internet marketing machine. We start by creating a rich, detailed listing with professional photographs. We have Tom and Susie's home professionally staged to look its absolute best. We create personalized web pages for their property and syndicate it to multiple real estate sites. With a top ranking at Google, Tom and Susie see Icon's multiple websites maximize their exposure to qualified buyers. They receive immediate notifications from our realtor and client database. We're proactive with selling our clients' property. We're constantly visiting homes, networking with contacts, and reaching out to other sellers. With the expertise of Icon agents, Tom and Susie know they will get top dollar for their property. That's money that Tom and Susie can use to raise their daughter.
Let us now discuss classification of agents. There are two types of classification of agents: rights of agent, duties of agent. Rights of an agent. An agent is entitled to receive agreed remuneration. In the absence of any special contract, payment for the performance of any act is not due to the agent until the completion. An agent may retain out of any sums received on account of the principal in the business of agency, or all money due to himself, respect of advance made or expenses properly incurred by him in conducting such business, and also such remuneration as may be payable to him for acting as agent. The absence of any contract to the contrary, the agent is entitled to particular line. Under certain circumstances, an agent can stop the goods in transit. The employer of an agent is bound to indemnity him against the consequences of all lawful acts done by such agent in exercise of authority conferred upon him. The principal must pay compensation to his agent in respect of injury caused to such agent by the principal's neglect or want of skill. Duties of an agent: to follow the instructions of the principal, to work with reasonable skill and diligence, to render proper accounts, to communicate with the principal in difficult situations, not to deal on his own account, to pay all sums. The agent is under an obligation to ensure that the contractual obligations are complied with. This duty would also encompass a duty to follow the lawful instructions of the principal, even though they may be foolish, unless they are illegal or unlawful. A duty of care is imposed on agents to ensure that they undertake their duties and obligations with due diligence. Even if this is not expressly stipulated, such a term will be implied by the courts into the agreement. Let us now discuss another topic, circumstances under which agency terminates. The agency relationship is not permanent. Either by action of the parties or by law, the relationship will eventually terminate. By act of the parties. Certainly, the parties to an agency contract can terminate the agreement. As with the creation of the relationship, the agreement may be terminated either expressly or implicitly. Express termination. Many agreements contain specified circumstances whose occurrence signals the end of the agency. The most obvious of these circumstances is the expiration of a fixed period of time. An agreement may also terminate on the accomplishment of a specified act following a specific event. Implied termination. There are a number of other circumstances that will spell the end of the relationship by implication. Unspecified events or changes in business conditions or the value of the subject matter of the agency might lead to a reasonable inference that the agency should be terminated or suspended. Where the agent terminates. Compensation is not usually payable where the agent terminates the contract. Agents are advised not to resign but to wait to be sacked, much as under employment law. Constructive termination. Compensation is still payable even where the agent resigns, where under regulation the contract was terminated because of circumstances attributable to the principal. If the principal has reduced commission substantially or removed an important and lucrative customer from the agent's list or changed the agent's area so that he will earn less money, then the agent may be justified in terminating and claiming compensation. Termination of the agency relationship. The agency agreement can be terminated by the operation of law in the following circumstances. Becoming an enemy of the state, the relationship ceases because the law prohibits any dealings with an enemy. Where the agency is an individual or a partnership on the death, bankruptcy, or mental incapacity of the individual. Where the agency is a company on the winding up of the agency. Let us now discuss duration and termination of agency. The relation of principal and agent can only be terminated by the act or agreement of the parties to the agency or by operation of law. An agency, when shown to have existed, will be presumed to have continued in the absence of anything to show its termination unless such a length of time has elapsed as destroys the presumption. The agent's duty to act on behalf of the principal comes to an end on the termination of agency. The time frame for termination of agency can be stipulated by a particular statute or instrument. An agency contract may be cancelled on the basis of an express stipulation in the contract. In such a case, the parties will have a right of cancellation at the will of either party or upon the happening of a contingency or the non-performance of some expressed condition. An agency may be revoked at the will of the principal when an agency is not coupled with an interest and no third party's rights are involved. An agency contract to be performed to the principal's satisfaction can generally be cancelled at will by the principal. The character of the notice also differs with respect to third parties. Thus, actual notice must be brought home to former customers who have dealt with the agency more directly while notice by publication will be sufficient as to other persons. When termination of agency takes effect, a contract of agency is a species of the general contract. As such, an agency may terminate in the same way as a contract is discharged, except where the agency is irrevocable. Termination by act of parties. A contract of agency may come to an end by the act of the parties as follows. By agreement. An agency is generally created by an agreement. It may also be terminated by an agreement so far as future transactions are concerned. By revocation by the principal. The principal may, except where the agency is coupled with interest, revoke the agency at any time before the authority has been exercised so as to bind the principal. However, where the authority has been partly exercised, the principal cannot revoke the authority in respect of acts and obligations already undertaken. Further, if the agency is for a particular period and it is revoked earlier without sufficient cause, the principal must compensate the agent. A reasonable notice of revocation to the agent and third party must be given. By revocation by the agent. An agent has also a right to revoke the agency by giving a reasonable notice in the same manner and with same liabilities regarding compensation. Termination by operation of law. An agency is terminated by operation of law as follows. By performance or completion of the act of agency, by expiry of time, by death or insanity of either the principal or agent, by insolvency of the principal, by dissolution of a company, by destruction of the subject matter, by the principal or agent becoming alien enemy, by termination of sub-agent's authority. Now, in the end, let us summarize what we have learnt in this lecture. The existence of agents does not, however, require a whole new law of torts or contracts. Temporary agencies are employment agencies that find employees to fill temporary jobs. For example, temps are often hired to work during seasonal increases in business or to cover vacations or illnesses. Agency coupled with an interest is when an agent has possession or control of the property of his principal and possesses legal rights against interference by third parties. A reasonable notice of revocation to the agent and third party must be given, otherwise the principal will be liable to third party for the acts of the agent and to the agent for compensation. The fact that apparent agency and hence apparent authority along with it is not found does not mean that if actual agency existed, apparent authority could not be found.